Tony Amendment Bill 2021, Bill number 15 of 2021, published on the 10th day of December, be now read a second time. Mr. Speaker, this bill and the Deeds Registry Amendment Bill constitute part of an array of measures in the form of legislative intervention intended to address a fundamental problem faced by our citizenry, more particularly those who own immovable property. One would not dispute the fundamental character, importance, and premium placed upon property in any society. A large part of the laws and indeed the legal system of every society are dedicated to the protection of property. Article 17 of the Universal Declaration of Human Rights provides, no one should be arbitrarily deprived of his property. Article 21 of the American Convention on Human Rights provides, no one shall be deprived of his property except upon payment of just compensation. By Article 142 of the Constitution of Guyana, our supreme law, the state guarantees to every citizen as a fundamental right and freedom, protection of private property from arbitrary deprivation. And the state also guarantees that no public property will be confiscated unless compensation is promptly paid in accordance with market value. This constitutional guarantee is accompanied by a myriad of legislation and the statute books of our country, providing a formidable protective network intended to safeguard property. This exists in both the civil and criminal arenas of the law. Notwithstanding, there have been an unusually high incidence of persons losing immovable property by fraud. I am of the considered view that there is a causal link between these fraudulent transactions and the peculiar system of land ownership which exists in Guyana. I speak, Mr. Speaker, of the ownership by a titular document called transport, which we inherited from our colonial past. In 1803, the Netherlands ceded the colony of Dutch Guyana to Great Britain. For over 100 years thereafter, there was a gradual supplantation of the British legal system and its laws in the colony. The process culminated in the year 1916 with the enactment of the Civil Law Ordinance of British Guyana. By that ordinance, from January the 1st, 1917, Guyana received the common law of England, including the doctrines of equity as was administered in England at the time. But there was one exception. It was expressly stated that the English common law of real property shall not apply to immovable property in Guyana. The law that existed in the colony at the time was in effect saved in certain areas and continue to be, to date, to be the law of Guyana. The law in relation to ownership of immovable property is one of those areas. Mr. Speaker, this transport system of ownership has some peculiarities about it which differentiate the type of land ownership that Guyana has from the rest of the Caribbean and indeed Great Britain. By this system of ownership, the concept of absolute title is embraced. And what that means is that only when the transport is in the name of the holder of that transport that legal title vests. What that means is that if one enters into an agreement of sale for the purchase of an immovable piece of property and may pay 99% of the purchase price of that property, that person gets no legal interest in that land and only gets a legal interest when the transport is actually passed into the name of that person. Compared with the rest of the Caribbean and with the United Kingdom, Upon the signing of an agreement of sale, the purchaser, though paying only 10% of the deposit, becomes what is called an equitable owner of the land, and the owner can only dispose of his interest in the land, the legal owner that is, subject to the interest of that equitable owner. That is not the case in Guyana. What happens in Guyana is that the papers, the conveyancing papers are filed with the deeds registry, and the law requires an advertisement of that transaction moving from the vendor to the purchaser to be advertised in the official gazette for a period to allow for any person who may have an interest in that property or who may owe, or who may be owed rather, a debt by the owner who is transferring, to lodge what is called a notice of opposition to that conveyance. And that is the way that the public is informed of this sale and can possibly stop that sale before the transport is passed. Up until that transport is passed, the purchaser, though as I said he may have paid a substantial amount of that purchase price, is not the owner and owns no legal interest that the law protects. All he has at his disposal is the equitable right to sue that vendor for specific performance of that contract. That peculiar system of land ownership, Mr. Speaker, has been abused in our country, and there are many, many cases that stand as evidence of that abuse. We have taken measures in the past to guard against these abuses and to create this protective network to which I make reference. Obviously, our efforts have so far been inadequate. For example, in 2012, I think, we piloted in this House, I as Attorney General, and enacted an amendment to the Deeds Registry Act that allows for agreements of sale to be recorded and filed as a record at the Deeds Registry, so that when a person wishes to buy a property, he can go at the Deeds Registry to see whether there are any previous purchase agreements signed in relation to that property. Because as I said, because the law doesn't confer upon a purchaser an interest in the land, it allows that vendor, dishonest vendor, to enter into multiple agreements of purchases for sale of the same property, drawing monies from several purchasers, and then dishonestly passing it to a third, or possibly jumping on a plane and leave these shores, leaving those persons with an agreement of sale for that land, but with no interest conferred by that agreement in relation to that land. We also in the past, in the year 2012, came to this House and passed another piece of legislation that allowed the official gazette to be put online. The mischief then was to address the issue of accessibility of the official gazette to not only people in Guyana, in particular the rural communities, but also persons who are living in the diaspora and who own property in Guyana, because there is a large faction of Guyanese who live in the diaspora, but they own properties in Guyana. Because they don't get access to a physical copy of the official gazette, which was the only medium of publication of that instrument, they were denied the opportunity to peruse that document on a regular basis, and therefore could not see when their transports would have been advertised for passing to a stranger or pursuant to an unauthorized and fraudulent sale. We attempted to correct that measure by putting the official gazette online, and now the official gazette can be accessed on the internet. We have a Facebook page. The official gazette is also accessible on many government websites, and we hope that it will be read more regularly so that persons can see not only the important government information and public information that is contained in an instrument like the official gazette, but more importantly, they can observe whether or not land transactions involving their own property is being fraudulently conveyed. Because, as I said, the law requires such transactions to be published in that official gazette. That measure still did not yield the desired success, and we still have cases where persons are losing their property with unusual frequency taking place in our country. I walked here to demonstrate the issue with a case that was recently decided by the Caribbean Court of Justice, and I'll read convenient excerpts from that case to illustrate the point that I want to make and the importance of this piece of legislation, as there is a direct bearing on this bill. There's a direct bearing of this case on the bill that is before us. The case that I wish to refer to, Mr. Speaker, is the case of Merlin Todd against Desiree Price and Jennifer Jibu. This is an appeal determined by the Caribbean Court of Justice in 2021. Mr. Speaker, when I was in private practice, I had the privilege of appearing in this case for Merlin Todd, the appellant, and the trial was done before Chief Justice Chang. We won the trial, and the case went to the Court of Appeal. The Court of Appeal ruled against me. I filed an appeal to the Caribbean Court of Justice, and the Court of Appeal decision was eventually reversed. But the important issue of this case, somebody said as usual, the Court of Appeal was reversed, but that's a different matter. So let me quote from the case itself so that you understand the factual matrix that I'm referring to. Alan Price, now deceased, owned a lot 153 Queenstown, Georgetown. In 2004, Anne Jennifer Jibu, claiming to act on behalf of Price, used a power of attorney to sell the land to Todd, who obtained a transport. It was subsequently discovered that the power of attorney was a fake, and Jibu was convicted of fraud. Price sued both Jibu and Todd in the High Court, seeking to set aside the sale and have the transport declared void. By Section 22 of the Deeds Registry Act, every transport vests in the transferee absolute title, but the proviso to the section contains an exception of a transport obtained by fraud in the hands of all parties or privies to a fraud. Price's claim against Jibu was a straight case of fraud. His claim against Todd was not on fraud. Rather, he claimed that by her negligence, she contributed to Jibu's fraud and the loss of his property. Price died before the trial, and the claim was continued by his widow, Desiree Price. Following a full trial in the High Court, Chang CJ delivered judgment in which he found that no fraud had been pleaded against Todd, and that it was impermissible at the trial to advance a case of fraud against her, and that in any event there was no evidence that she was privy to fraud. Accordingly, he refused to declare the transport of Todd void and to set it aside. So you have a case here, Mr. Speaker, where Mr. Price did no wrong. Resident in the United States of America, a fraudster by the name of Jibu concocted a power of attorney pretending that it was authorized and made by Price, authorizing her to sell his property. And he sold it to Todd. Todd made all the searches at the deeds registry, confirmed, as the judgment would later reveal, that the instrument, the power of attorney, was duly recorded. It was duly filed in accordance with the laws. The registrar of deeds is the one who executed the power of attorney, and one would have expected that such a responsible office holder would have ensured that the power was properly executed. That was not the case. So Price lost his property. Todd was able to benefit. She did no wrong either. She did no wrong either. No fraud was alleged against her. The fraud was alleged against Jibu, who coincidentally was charged with the fraud, went to the magistrate's court, pleaded guilty to the fraud, and was sentenced. The tragedy of it all is Price lost a valuable piece of property through no negligence because the system failed. That is what happened in the case. And in several parts of the case, this is an important passage that I want to share. This is what the judge said. In this case, the forged power of attorney was relied on by Todd only because it was duly registered and had been so registered by no less eminent and trustworthy a person than the Deputy Registrar of Deeds, who had certified that Alan Price had personally appeared before him and affirmed that he had executed a power of attorney. In considering the matter of the loss that one or perhaps both innocent parties must suffer, fairness requires a recognition of that loss and a deficiency in the system. So, there you had the record show that Mr. Price appeared, because when a notary public, who is the officer duly authorized to execute an instrument called a power of attorney, he is required to affix a seal, and that seal signifies that he would have seen the person appeared before him personally and append his or her signature. Unfortunately, in reality, that does not happen. And it did not happen in Price's case. The evidence showed that at the time when that instrument was purportedly executed by Price, at the Deeds Registry, Georgetown, Guyana, Price was in the United States of America. His passport did not show that he was anywhere close to Guyana at the time. Mr. Speaker, the judges of the CCJ, in several portions of the case, call upon the government of Guyana to rectify this situation. I want to read a passage here where that call was made. It is my hope, this is Justice Jamadar speaking, it is my hope that the judgment of the High Court, the Court of Appeal, and this court will be placed before the Honorable Attorney General of Guyana for his careful consideration and possible action. I am convinced, and respectfully so, that there is urgent need for review and for appropriate reform to be taken in this area of the law. And there are other passages from different judges in the case calling upon the Parliament of Guyana to intervene and strengthen our system of land ownership and other areas of the law in order to protect private property. The government of Guyana, and indeed the Parliament of Guyana, is heeding the admonitions of our apex court, the Caribbean Court of Justice, by these proposed legislative reforms. We did similarly when we removed from our statute book what is loosely referred to as cross-dressing legislation, after the CCJ declared that it was an offense, that the offense that cross-dressing effected was in conflict with our constitutional provisions. Indeed, the President of the CCJ has since publicly congratulated the government and the Parliament of Guyana for giving effect to the decision of our apex court. As was evident in the Marlon Todd's case, a power of attorney was used as the instrument to perpetrate the fraud that caused Mr. Price to lose his valuable property. There are numerous other cases to which I can point where powers of attorney have been used in like fashion to commit fraud and trickery. Many are currently under police investigations. I know for a fact that only this morning a few persons were arrested and taken to CID, where a power of attorney again, it's alleged, was fraudulently executed, and a person used that power of attorney to mortgage a property to the bank, and the bank executed a mortgage on a property and disbursed millions of dollars in loans to a person who was apparently acting under a power of attorney that was forged. A power of attorney by law must be executed. Several administrative decisions were taken and policies implemented at the deeds registry to strengthen the system there. However, they were not enough. They are not enough. Unfortunately, in many cases, those who prepared illegal instruments, such as powers of attorney, are either complicit in the fraud or are negligently executing their statutory functions, and that contributes significantly to the creation of fraudulent and illegal instruments. A power of attorney by law must be executed before a notary public or a magistrate. One would think that a person holding such a high office will not be particip criminis or would exercise his functions with due circumspection and care. At a minimum, one would expect that they would take the necessary steps to verify the identity of the witnesses, of the persons involved in the transactions, and they would physically witness the appending of their signatures to the document. Clearly, that does not take place, as exemplified by the Moreland Tutt case. This bill seeks to mandate a regime of measures which the parties to such an instrument and the person before whom it is executed must follow for the instrument to be valid. The deeds registry is prohibited from registering, filing, or recording in the registry any power of attorney that does not comply with this regime of measures. Mr. Speaker, the bill in the first clause adds a new clause to the Principal Act. And in this new clause, it adds the regime of measures to which I am referring. The bill is crafted in commendably simple language, so I'll read it very briefly so that members would understand what the drafter intends to achieve. 2A is the new section that will go after 2 in the Principal Act, and it reads 2A1, an instrument creating a power of attorney shall be executed with the donor of the power and the donee of the power, meaning the grantor and the grantee, appearing personally together before a notary, a public notary or magistrate, as the law may require, and the donor and donee shall each provide the public notary or magistrate with 2 photograph identification documents that establish their identity and a photocopy of each document. The honorable member, I believe, Mr. Ramjatan, speaking through his mask, was signaling to me why 2 forms of identification. 2 forms of identification, honorable member, because that is the type of stringent requirement which we deliberately want to insert in the law. So that you can't, we have found that there is evidence of forged ID cards. So you can have a forged ID card, but it's also difficult at the same time to get a forged driver's license or a forged passport at the same time, unless you're a master forger. So we are simply making it difficult for those who intends to commit fraud. We are making it difficult for them to do so. If you don't have 2 forms of pictorial identification, well, then you can't execute a power, neither can you be the recipient of the power. It is as simple as that, and that is the intention of this bill. We do not intend to dilute the importance of that. Somebody said brain is free. 2A2, where the donor is out of Guyana and the donee is in Guyana, and this section speaks specifically to the Guyanese reality, where a large part of our population lives in the diaspora, but they have people in Guyana who transact the business on their behalf by the use of that instrument called a power of attorney. We are strengthening it for those persons as well, even though they may be executing it in a foreign country. And this also is in keeping with our Evidence Act, where the donor is out of Guyana and the donee is in Guyana. The donor and the donee shall each appear personally before a notary public or magistrate as the law may require in the country in which he is, in the country in which he is, and execute the power of attorney, providing the notary public or magistrate with 2 photograph identification documents that establish his identity and a photocopy of each document. So, if one party is in New York, in Richmond Hill, they must find a notary on Liberty Avenue or somewhere close by in Brooklyn, if they are in Brooklyn, and execute that instrument and provide the 2 pictorial identification sources to which the law refers, or else it will not be a valid power. The power of attorney shall specify the name and number of every identification document of the donor and the donee. The power of attorney shall be signed by the donor and the donee in the presence of a notary public or magistrate and 2 witnesses, and subscribed by the witnesses in the presence of each other before being signed, sealed or stamped by the notary or magistrate, provided that where the donor executes the power of attorney out of Guyana, a separate witness statement shall be given by one of the subscribing witnesses. So if the thing is done in New York, in addition to the 2 witnesses who must sign as subscribing witnesses, present when the donee is when the donor is signing, one of those witnesses must also execute an affidavit of due and proper execution and attach it to the instrument, send it to Guyana, and then the donee in Guyana, if he wants to act upon that, must complete the other side of the transaction by him appearing before a notary and complying with the laws as it applies in Guyana. The power of attorney shall not, and this is where the deeds registry comes in now, the power of attorney shall not be registered, filed or recorded in the deeds registry unless the power of attorney has attached to it copies of the 2 photograph identification documents, biodata page in the case of a passport of the donor and donee, and separate witness statement given under subsection 4, which have been certified, signed, sealed, or stamped by notary public or magistrate. For the purpose of this section, identification documents include a national ID card, a valid passport, and a valid driver's license. Now it is expected that this compendium of measures will go a far way in protecting those instruments, the powers of attorney, so as to prevent miscreants from perpetrating fraud using these instruments as the vehicle. Now, in the Principal Act, there is a section that exempts a category of powers of attorney from complying with certain formalities, including it having to be filed at the deeds registry for public record. Those types of power of attorneys are special powers of attorney under the Act, and they allow you to pass transport and to take out a mortgage. Well, we are collapsing that provision into this, and we are saying that even those powers of attorney in the Principal Act, they must comply with these provisions or else they will not be valid. Because we don't want to leave unchecked any category of instrument that can be used as a power of attorney. We don't want to exempt them from this menu of safeguards. We want to include them. So now any one of those powers of attorney that did not have to comply with formalities before will now have to comply with the regime set out in this act. And then the bill continues to list a series of offenses for anyone who violates what this act prohibits. So the act is now amended, the principal act is now amended, and a series of offenses are inserted. For example, clause 4 says, a person shall not dishonestly obtain a power of attorney, A, to obtain financial advantage for the person or another person, or to cause loss to the principal or another person. An attorney under a power of attorney shall not dishonestly use the power of attorney to obtain financial advantage for the attorney or another person, or to cause loss to the donor of the power or another person. Any attorney who fails to comply with this subsection commits an offense and is liable to, on a summary conviction, to a fine of $5 million and to imprisonment for 5 years. And in the case of a body corporate, $10 million. Then there are other offenses directed to the notary now. If any notary public who is suspended or removed from practice or whose name is not on the register, whether for reward or not, makes, does, or exercises or performs any act, matter, or thing pertaining to or belonging to the office, function, or practice of public notary, the public notary commits an offense. Then there is one that goes to any person. A person who willfully certifies or propounds any false statement or document, or who fraudulently with intent to deceive, conceals, withholds, or perverts any fact or document pertinent to the subject of a power of attorney commits an offense. A person who fails to comply with any of the duties imposed on the person under section 2A commits an offense. A person who commits an offense under this section is liable on summary conviction to a fine of $5 million and to imprisonment for 5 years. The minister may make provisions, regulations to bring the bill into force. The minister may make regulations as may be necessary for the better carrying out of the provisions of this act. So, Mr. Speaker, this act may be small in its size, but it has deep and far-reaching ramifications for the protection of property in Guyana. The CCJ, in their judgment, recommended a number of changes. We are going to implement them in stages. We began long before the CCJ called upon us to do so. I spoke of the Deeds Registry Act Amendment Bill in 2012 that allowed for the registration of agreements of sale. I also spoke of the Official Gazette Online Bill, which allowed for the publication of the Official Gazette Online to make it readily available. This is another piece of legislation that intends to strengthen that protective apparatus to ensure that our transported properties are protected. And why I'm emphasizing on transported property is because in Guyana there is another system of land ownership introduced in 1961, the Australian Torrens system of land registration that issues a certificate of title. That coexists side by side with the Deeds Registry Act and the Roman Dutch system of ownership. But in the incidence of fraud that we have unearthed over the years, there is not a corresponding number of fraud being committed in that system of land ownership. And that has to do with the swift way that that system works. When you go to the registrar of lands with all the conveyancing documents and you hand it over to them, that is the end of the transaction. The purchaser who is in that transaction, from that moment that the registrar of deeds registrar of lands take custody of those documents, becomes the owner without the registration of the certificate actually issued to them. It becomes by operation of law, because after those documents are submitted, nothing can change the registration of that certificate into the name of the new owner. There is no 3 months period for advertisements in the official gazette, etc. So you don't find in that system of ownership many instances of fraud. Of course, in Marlon Todd's case, where the power of attorney was used, it could have been a certificate of title, or it could have been a transport. Because what was used as the vehicle there was the power of attorney. So, Jibu, even if the property was owned by a certificate of title, would have still, based upon the facts, succeeded using a fraudulent power to transfer the title over to Todd as it occurred. So the system of ownership didn't matter in that case. But one examines, and the lawyers would know what I'm speaking about, on both sides of the house. When one examines the reported cases and the incidents of fraud against immovable property, it occurs more with transported properties rather than with certificate of registration type properties. So, Mr. Speaker, this is a very important bill, and I commend this bill to the House.